Welcome back to my YouTube channel, VaJee, a Center for Legal Excellence. In the series of BNS, we are breaking down every definition into deep details so that you can develop your own understanding. Okay, in this particular video, what I am going to deal first, I have detailed breakdown of the definition. Thereafter, I compared with dishonestly, fraudulently, I compared with dishonestly, and next is how that fraudulently it's a mens rea. It's a mental state and how in the main provisions it's incorporated. And lastly, a constitutional backing of it. Okay, without wasting any further time, let's go through it into detail. Okay, today I'm dealing with section 2, subsection 9, which defines the term fraudulently. It's defined as doing anything with the intention to defraud, but not otherwise. Let's go through it into detail. First is there is intention to defraud. The essence of acting fraudulently in the specific mental state aimed at deception. Unlikely or dishonestly, it does not strictly require a wrongful gain or wrongful loss of a property, although in practice an intention to cause some form of injury or disadvantage usually accompanies the deceit. But that is not the whole motive. Whole motive only to defraud, but not otherwise. What we mean by this term specifically, this phrase emphasizes that if the intention to defraud is missing, the act cannot be categorized as fraudulent under this specific section, regardless of its other consequences. Okay, if we compare it to the term of dishonesty, because these two terms are interchangeably used very frequently, then BNS maintain a clear distinction between two type of mens rea. On a one hand, dishonesty focus on the economic results, intentionally causing wrongful gain to one person and wrongful loss to another person, whereas fraudulently, section 2, subsection 9 focus on the act of deceit. A person can act fraudulently without seeking a monetary gain, such as forging a document to gain a non-material advantage. Sometimes we forge a passes, which might be available and might not be. Well, that's not a per se a very heinous passes to enter into a park. So that is a penalty that you are entering without ticket. But if there is a no ticket and you just need to fast pass so that they have a count ki how many number of people are there in the park, and there is overcrowding or something, and you just petty offense you committed. So this is not as heinous as dishonesty, because there you are harming other person. Okay, and fraudulent intention is a critical element in several other offenses defined under the act. Let's go through it into detail. First is counterfeiting, defined under section 2, subsection 4. What it says counterfeiting involves causing one thing to resemble another thing to practice deception or knowing such deception is likely. Key ingredient here is a deception. And what is the law explicitly states that the imitation does need not to be exact, need not to be perfect to qualify as a counterfeit. If the resemblances are strong enough that a person might be deceived, the court shall presume the accused had a fraudulent intention unless they can provide it otherwise. In this particular application, this standard is used for serious offenses involving the imitation of coins, government stamp, and currency note. The BNS treat counterfeiting of state control item much more severe than a private marks. There can be a violation of trademark and private marks, property marks, but these kind of counterfeiting, government take a actually very serious note. How is it so? I can give you few examples. Like under Section 178, provide for counterfeiting of coins, currency note, or stamp is punishable with the imprisonment for the life and up to 10 years or plus fine is provided. And in Section 341, counterfeiting of seal with the intention to forge a valuable security under Section 338 carries a punishment for life or up to 7 years of imprisonment. And similarly, property marks under Section 347, counterfeiting a mark used by another person carries a much lighter penalty, up to 2 years of a fine or both. So, hope I made my point clear because state has mm, a, uh, whole country to run. It's counterfeiting of coins cannot be allowed by court. If it is, say, suppose if there is a leakage, the whole economy could collapse. So we are making sure of it, and that's where, by the severity of punishment, you can make out that how much government is serious about these particular crimes. Okay. Next is fraudulent deeds and disposition. This section targets individuals who use deception to shield their asset from legitimate creditors. For example, under Section 320, it criminalizes the fraudulent removal or concealment of property to prevent its distribution among creditors. And next is Section 321. It's punishes the fraudulently preventing a debt due to the offender from being made available to satisfy their own creditors. Under Section 322, penalizes signing transfer deed that contain false statement regarding the consideration payment or the intended beneficiary. And 323 covers the fraudulent release of any demand or claim to which the person is entitled. Okay. Next core offense is cheating. Cheating sounds simple, but actually it's a very wider term because here the scope of harm is very wide. Cheating requires deceive a person to fraudulently, dishonestly induce them to deliver a property or consent to retain that property. Unlikely, many property crimes of fraudulent intention in cheating includes inducing a person to do something that causes harm not only just to a property but also their body, mind, and reputation. And deception by the concealment, it's a very it's specifically included in this particular offense. The law very particularly clarifies that dishonest concealment of fact in itself a form of deception. Okay. And there are other forms of cheatings as well because it's a very broader term. Like 318 subsection 4 talks about someone to deliver property or alter a valuable security carried up to a 7-year imprisonment or a fine. And pretending, 319 subsection 2 talks about pretending to be someone else to cheat carries up to a 5 year of imprisonment or a fine or both. Okay. And simple cheating, 318 subsection 2 provides a punishment for that. This carries a penalty of 3 years or fine or a fine or both. Okay. So here are different types of cheating we have discussed. Not complete, but yeah, these are the facet of it. And most important is mm, next most important is forgery. Forgery particularly is very important. Why it is so? Because forgery is the making of false document or electronic record with the intention to commit a fraud or cause an injury. Okay. Here, what Section 335 provides, this includes signing or executing a document to make it appear as if it was authorized by a person who did not actually grant the authority. It punishes those kind of offense here. And next is non-material intent. One can commit forgery without seeking any money. For example, forging a document to support a claim of title or to induce someone to enter into a contract is sufficient for liabilities. Okay, and here we discussing penalty for the forgery depending largely on the type of document or the intended use. Here are a few examples I illustrated for your consideration. First is under Section 338, what it provides, forging these sensitive, valuable security or wills. It's provide for if you are forging these sensitive document, is punishable imprisonment for life or up to 10 years and fine. Okay. And next is Section 337. It's provide a court records or identity document. If you are forging Aadhaar cards, voter IDs, or court proceedings, carrying up to 7 years of imprisonment and fine. And Section 336, subsection 3 provides for forgery for cheating. If intent is specifically to cheat, the penalty is up to 7 years or a fine and a fine. And simple forgery punishable under Section 336, subsection 2. The base penalty for making a false document is up to 2 years of imprisonment or a fine and a fine or both. Okay. Next main thing is that fraudulent decrees. That is actually a very serious offense. This section addresses the misuse of judicial process to commit a fraud. Section 245. 245 punishes those who fraudulently allow a court decree to be passed against them for a sum not due or a sum larger than what is owed. Then they are specifically punished under this section. Section 247 targets the opposite, fraudulently obtaining a decree against another person for the property or money to which the offender is not entitled. Okay, what is the specific purpose of this? This often occurs in a collusive suit where the debtor allows a friend to get a fake judgment against them to prevent a real creditor from seizing that particular property. These offenses typically carry a shorter term, focusing on the misuse of property and legal processes. Say, suppose if you make a fraudulent deed which is punishable under Section 322, 323, concealing the property to prevent distribution to creditor or executing a deed with a false statement carries punishment between 2 to 3 years or a fine or a both. Okay. And next is fraudulent decrees, 245 and 247. Suffering or obtaining a court decree for a sum not due is punishable up to 2 years or a fine and a fine or a both. Okay. Next, I'm going to deal practical implications. Okay. Under BNS, Bharatiya Nyaya Sanhita, Section 2, Subclause 4, and the Section 2, Subclause 4, Explanation 2. If the prosecution proved that the accused created a resemblance strong enough to deceive a person, the court must assume the accused intended to practice a deception. Means for a counterfeiting, there you need to establish that there is some kind of imitation. That need not to be exact. That need not to be in a perfect detail. If a common man say that both things look similar and anybody of journal prudence can be deceived, then you commit a deception. And there is a presumption in favor of it that if the prosecution proves that the accused created a resemblance strong enough to deceive a person, the court must assume the accused intended to practice deception. You cannot claim a good faith clause. Simple. This shift, generally, what happens now, if you are claiming something, then you have to prove. But here, accused have to prove that he is innocent. There is uh, that maxim doesn't applicable here, that you have to prove the crime of accused beyond the reasonable doubt. No, there is a prima facie doubt on the part of a accused, and the burden of proof it shift to the accused, not on the prosecution. And to revert this, the accused must provide evidence showing a legitimate, non-deceptive reason for creating that resemblance. And perfection in imitation is not required for the presumption to trigger a good enough resemblance is sufficient here. Okay. And when we talk of relevancy under Bharatiya Sakshya Adhiniyam, Section 12 particularly make these kind of facts relevant, like facts showing the existence of intention, knowledge, good faith, and fraudulently. Particular use of the word fraudulently and fraudulent intent are considered relevant facts when those state of mind are in issue. And to provide proof that particular state of mind, the evidence must relate to the specific matter at hand, not just a general deposition towards the dishonestly. And general depositions doesn't work here. And Section 12 explanation to a previous conviction for an offense can be used as a relevant fact to help to prove the accused state of mind in a current trial. Okay, this is particularly I deal with the evidentiary value. कि How fraudulent intention is admissible in criminal laws. Bharatiya Sakshya Adhiniyam, Section 12 specifically deal about it. Okay. Next is the constitutional backing. That Article 20 clause 3. Article 20 clause 3 provides for that. While the BNS in Bharatiya Sakshya Adhiniyam, we are presuming an intention. If whatever fraudulent intention, we can give a fact to prove that, and that are admissible under Section 12. And there is a presumption, if you are counterfeiting a coin, there is a prima facie position that you counterfeit. BNS, Bharatiya Nyaya Sanhita 2, subsection 4 presume in favor of this. But Constitution 20 subclause 3 provides a specific safeguard to this. What it says that an accused from being compelled to witness against themselves cannot be compelled to witness against themselves. However, the Supreme Court has ruled that being compelled to provide a specimen handwritings and or a signature does not violate the rights, as is considered furnishing evidence, not being a witness. Okay. So here I dealt about this particular topic in a bit detail. And if any more clarification or any more clarity on this topic is needed, just let me know in the comments. Thank you.